Hi, everyone. Thank you so much for joining us for tonight's webinar, Understanding Substantive and Procedural Due Process. Our presentation tonight is being led by the amazing Karen Waples. My name is Tiffany Tang, and I'm the Associate Marketing Manager for BFW Publishers. I work specifically with our AP Economics and AP Government programs. If you're not familiar with BFW, we're specifically an AP publisher, and we really pride ourselves on creating full teacher resource suites. So that's things like a teacher's edition, teacher resource materials, and test banks, things of that nature. Without further ado, I'm just going to go ahead and hand it off to Karen to get us started.
Thanks, Tiffany, and thanks to all of you for being here this evening. If you're like I am, this is the point at which the semester is starting to get a little nuts. By the time I walked into school this morning, I already had 2 kids waiting for me to go over essays. And so I know how busy you all are this time of year. And so thank you so much for spending a little bit of time with us tonight. I'm Karen Waples. I teach at Holy Family High School in Broomfield, Colorado, and I have a great job. I am sort of retired. I had the world's shortest retirement, and so now I have a part-time job teaching a year-long combined AP US government and comparative government class, and then a second class that is a year-long comparative government class. And love my classes this year. The kids are great. I don't have any problem kids. I have one potential problem parent, but no problem kids. And it's been a great year so far. And I hope you're all having a great year too. I'm the co-author of American Government Stories of a Nation, and I'm actually working on an updated version of that now, which is really fun. And I'm the author of Comparative Government Stories of the World for the comparative government class. And for those of you who don't teach comparative government, if you're interested, please reach out. It is a fabulous, fabulous course. So when Tiffany and I were talking about what we wanted to do for a webinar, I decided on due process because when the College Board released its CED, and for those of you who are relatively new, that stands for Curriculum and Exam Description. College Board likes its acronyms. When they released the CED this summer, I noticed that they had updated their discussion of due process. So they had added in some court cases. They also added substantive due process. There was a brief discussion of procedural due process before, and now there's a more in-depth discussion of substantive due process. And I thought this would be an interesting topic, the difference between the two and how those might appear on the exam. And they're kind of tricky concepts to wrap your head around. And in doing research for this, it was hard for me to wrap my head around it, even though I went to law school back when the dinosaurs roamed the earth. And so I thought about how can we get this difficult concept across to students in a way that's understandable without dumbing it down. So just as an overview, due process really means treating people fairly. So it means the government treating people fairly. And what I tell my students is what is due is what is owed to you. And then the process is the treatment. So it means the treatment that's owed to you, the fair treatment. And at least initially in the Constitution, it protects life, liberty, and property. And we'll go through those provisions in a minute here. We can find due process a couple of places in the Constitution. And so then due process is divided into 2 categories, substantive and procedural. And so one of the things I thought we could do this evening is talk about the differences between those two. And how we can address those with students. So the first place we find due process is in the Fifth Amendment. No person shall be deprived of life, liberty, or property without due process of law. And initially, and you guys all teach selective incorporation, initially this clause applied to the federal government until the 14th Amendment was passed and the court began the process of selective incorporation. This due process clause applied to the federal government. And then, of course, as you all know, following the Civil War, the 14th Amendment was passed. And part of the 14th Amendment, the due process clause, says no state shall deprive any person of life, liberty, or property without due process of law. So the 14th Amendment becomes the vehicle through which due process rights are applied to the states. And so, you know, we originally had the Fifth Amendment, now we have the 14th Amendment. Just in terms of student understanding, when you get to the 14th Amendment, and I didn't put it in this slide because I didn't want to overcomplicate things, you do want to make sure that kids don't confuse the Equal Protection Clause, which prevents discrimination, against the Due Process Clause, which is more of an individual liberty. So they might get that confused. You know, they might look at Brown versus Board of Education and think 14th Amendment due process. And this is when it's helpful to sort out the difference between those two clauses of the 14th Amendment. So my next task, as I got ready to prepare for this, was to go through the CED and figure out how does the CED handle due process. And as it turns out, they split procedural and substantive due process. And so here's what the CED says. Procedural due process requires that government officials use methods that are not arbitrary when making and carrying out decisions involving constitutionally protected rights. And so the way I would explain this to students is it's the steps the government must take in carrying out the law. So it's not, is the law itself fair? It's, did the government treat you fairly in the way it acted? So for example, if you were thrown in jail and the law said you had access to an attorney, but you know, and you asked for an attorney and one was never provided, that would be procedural due process. The law itself was fair. The way it was carried out was not fair. The process that the government through, or, you know, if they didn't tell you what the charges were against you or didn't provide you with a speedy trial. So I think a way I would put this with kids is that procedural due process means the government must follow the rules. It's a little overly simplified, but I think that's the way that kids might understand it.
Some Supreme Court justices are skeptical that we have substantive due process. Why would some promote that stance about the law? Do you have an opinion or any insight on that, Karen?
Yes, because they don't think there's a need for substantive due process because they believe that other rights conveyed in the Bill of Rights are sufficient to cover individual rights and liberties. So adding substantive due process in some of their viewpoints is unnecessary because the Constitution already provides rights.
Does this relate to the Fifth and the 14th Amendments in different ways?
It can. So the Fifth Amendment directly relates to, right, the life, liberty, and property and the federal government. The 14th Amendment, which incorporates the Fifth Amendment. So originally the Fifth Amendment applied to federal government action. Through the 14th Amendment, which repeats the language in the Fifth Amendment, then various rights are incorporated to the states. So while I told you this was complicated, while the 14th and Fifth Amendment involve the same rights, the states are not they're not held actionable for those rights until the 14th Amendment is passed. So most cases that involve state action go through the 14th Amendment. All right, so back to the CED. They mention procedural rights of the accused, like rights against unreasonable searches and seizures, and the idea that there's this tension between liberty and order in the CED, the idea that order and security don't eclipse basic liberties. And this part of the CED was there before. This is not something new. So you're probably very familiar with this. And this would be cases that, aren't necessarily required cases, but that you probably cover in your class, like Mapp versus Ohio, for example. And then the next part of the CED, and again, this is nothing new, protects the rights of accused during the trial, such as their right to an attorney. So this has always been there, and the required case that we would refer to would be the Gideon case with regard to this particular EK. EK, by the way, stands for essential knowledge. For those of you who are new, they have divided the CED into essential knowledge statements. Now, here's where things start to get, in my opinion, interesting. I'm glad they added this, but this is new to the CED. So substantive due process involves why certain rights are fundamental. And we'll get to the Dobbs case in a minute, because of course that was really sort of the center around the Dobbs case. And the idea is the law itself fair? Are there certain rights that are fundamental, and they can be either enumerated or inferred from the context? And we had a question earlier about, does substantive due process even exist? Well, it kind of depends on how you interpret the Constitution. If you think it's the duty of judges or the role of judges to infer rights from the Constitution, and we'll talk about the right of privacy in a minute, then you might be more supportive of the idea of substantive due process rights. If you think judges should just look at the historical background and language of the Constitution and not, if you will, read rights into the Constitution, then you're going to be less supportive of the idea of substantive due process. So the issue is, when does a right become a fundamental right? And that's something the court has to wrestle with. And that brings us to the big change in the CED, which is the discussions of Griswold, Roe versus Wade, which was in there before, but in a different way, and Dobbs versus Jackson's Women Health Organization. So the CED classifies this as a discussion of substantive due process. And just for a quick review, Griswold versus Connecticut ruled that there is a right of privacy implied in the Constitution, and the judges used the word penumbra, which is like Latin for a shadow or umbrella of privacy. And then, of course, in Roe versus Wade, which used to be a required course, but isn't anymore because it's been overturned, the court ruled that the right to an abortion was applicable under substantive due process because of the right of privacy that was articulated in Griswold. And then, as you all know, Dobbs overturned Roe versus Wade, holding that the Constitution does not confer a substantive due process right or right of privacy involving abortion. And then this gets really interesting as AP government teachers. What used to be discussed in civil liberties under the right of privacy, we can now also talk about with federalism and states versus national authority, because this has really become a state-by-state issue. And so as I'm writing this updated textbook, I'm finding I have to address Dobbs twice, right? Once with federalism, and then again with the right of privacy, with civil liberties. So here's what I think we need to know as AP teachers, because this, of course, I teach in Catholic schools, so this is going to be really interesting to teach. Your kids need to know what is on this slide, and what's on this slide is fair game for a multiple choice question. And I don't work for the College Board. I don't have any insider information into this. I just know that if it's not in an EK, it can't be tested directly in a multiple choice question. It is now in an EK, which means that students are supposed to know what's on this slide. That does not make these required cases. So we could see this in multiple choice. Something else we could see in multiple choice is another court case that they've never seen before, but that has enough context that they would be able to determine the answer. But we will not see these as required cases in the SCOTUS question, which is free response question number 3. Now, you guys know there are required cases and non-required cases in the SCOTUS question. These could appear in the SCOTUS question, but they would appear as the non-required case, which means that they would be given the facts, they would be given the ruling, all of the context that they needed, and then they could compare it to a required case. I don't know what that case would be, but they could, compare it, I guess, to another substantive due process case. So I hope this hasn't thrown us for too much of a loop, because I get really nervous when there are changes made to the curriculum. Clearly, the College Board had to do something with Roe versus Wade and Dobbs versus Jackson. And what they decided to do was include it in an EK, allow it to be tested in multiple choice, but not make these required cases. And that's a very big distinction. So we are now down to 14 required cases with the death of Roe, as opposed to the 15 that we had before. So there may be questions about this. Tiffany, do we have any questions?
Someone asked if we use Casey versus Planned Parenthood in, I guess, the text. And I guess you could speak a little bit about like how cases are like chosen and things like that. Just a pinch.
Yeah, that's a really good question. Let me say this. It's hard to decide which cases to include and which cases not to include. We do discuss Casey in the text because it provides context for the rules that were established regarding abortion following Roe versus Wade. And so you'll see a lot of things in the text that aren't a required case and can't appear in multiple choice, but help kids understand what is there. So that anything that appears that is not in the CED is there because I think it provides some context for what's going on. This is completely unrelated, but I was working on a chapter today about presidential powers and the War Powers Resolution. I could not find that in the CED. I mean, maybe it's there, but I searched for it and I couldn't find it. But I thought I've got to include it in the textbook because it's incredibly important. And so, I make a decision as an author. Will this provide context for kids to help them understand the topic better? And then part of it's just like, do I think this is really important, even though it may not be in the CED? It's funny that you brought that up. I have a list of I'm looking at it here, about 10 new court cases that I feel like I need to add to this updated edition, and none of them are required cases. So it's going to be a really short treatment, but they are cases that change the law pretty substantially. There's this tension between just wanting to teach what's on the test and giving kids a little greater overview of a topic and giving them some context. And that's always the side I come down on. That was a very long answer to that question.
Is substantive and the penumbra concepts interchangeable?
Penumbra was really related to the right of privacy, right? That in that discussion in Griswold, that really related to the right of privacy, that there was a shadow of privacy that sort of was lurking in the Constitution. I'm trying to think if there are shadows of other things that lurk in the Constitution. I have only seen it in that context. So I'm not going to say no. I think it's a great question, but they were dealt with separately, right? The shadow of privacy in the Constitution came from reading several amendments together, and clearly provided a substantive due process right. But I think you can have substantive due process rights that are more in your face and blatant, like the right not to have your life taken away unless you have committed a felony murder. I don't think that's a shadow in the Constitution. That is life, liberty, and property that comes straight out of the 15th and 14th Amendments. So I think some substantive due process rights are fairly shadowy, but I don't think it's the same as a penumbra, because some of them are very explicit.
Two questions that relate back to these specific cases, like Griswold and Roe. So someone mentioned that Roe was overturned because it was not deemed to be in the Constitution. So it means the federal government cannot tell states how to regulate abortion, and that was the question. And then I'm also going to tell you like the second question as well, because I'm not sure if we can fold it in. Someone mentioned that they struggled with cases like Griswold, Roe, and Obergefell because they fall into this penumbra where judges get to flesh out what they think is constitutional and what is not constitutional. Does it come down to democracy of a majority of 5 or more at one time in history? Can we live with overturning, quote, wrong judgments like Plessy or Roe?
That's
big questions.
Those are big questions. And it's funny because I had a student ask me almost the same thing today. Ultimately what it comes down to is the particular set of judges on the court and what their viewpoint is towards the rights in the Constitution. And ultimately it comes down to, are they originalists or strict constructionists who want to stick with, a couple of things here, either the founders' intent, and they talk about this a lot in Dobbs versus Jackson, right? That the founders never intended for abortion to be legal. And if you've read the Dobbs case, there's a very long history of abortion law in the United States that they use to back up their judgment, or the judges who believe that the Constitution is a vague document written purposely to be vague so that it could be interpreted over time and change with the times. And so we get a lot of discussion in the news is about the ideology of members of the court. And I think that's important, but I think it's also constitutional philosophy that's important. And those are different things. So ultimately, whether we think a decision is wrong or not, we have to live with it. And most judges have said that they're going to be very careful in overturning precedent. We've seen cases where they've overturned precedent pretty quickly. Citizens United overturned a precedent that had occurred just a couple of years before. Whoever asked the question, you indicate in your question, not all precedent is correct. And so then should judges live with it, even though they think it's wrong? That's the nice thing about having the power of judicial review is if you get a Plessy versus Ferguson, which was clearly a wrong-headed decision, the court has the power in the future to overturn it. They're not stuck with precedent for life, although at the same time, they need to respect it.
No, but there's actually a really interesting comment I think you'll appreciate. Students ask these hard questions, but I think they're implying that the court loves to, quote, black and white the gray areas.
They do. Well, and to be fair, to a degree, the court has to black and white the gray areas because they have to make a decision. The court can't say on the one hand, right, abortion should be protected under a right of privacy for these reasons, but on the other hand, it shouldn't be protected for these other reasons. You know, they kind of have to pick a side and go with it. And you're right, sometimes that looks very black and white. And thank goodness we have students who ask these kinds of questions. We're really lucky in that regard. These are some cases that involve due process under the 14th Amendment. These are from our required cases. And note that each of these cases involves action by the state. So we have other required cases where rights were violated, like New York Times versus Sullivan, but, you know, or New York Times versus United States. But, you know, that is a straight up First Amendment case, and that involved the federal government. These are the cases that involve state governments where rights in the Bill of Rights are applied to the states through the due process clause. And so I got to thinking about this. I think kids might get something on the exam, and I don't have any insider information about the exam, none. But I could see where they might get something like Gideon versus Wainwright, which is a required case, and then something else like, you know, Brandenburg versus Ohio or Mapp versus Ohio that involved a different right. And so kids might want to say Sixth Amendment, right to counsel for Gideon, but then if they get Mapp versus Ohio, they're going to want to say Fourth Amendment. And that's going to be a problem because they would have trouble identifying the constitutional clause that they have in common. And so I think one way to teach this is to teach the due process clause as a clause that these cases have in common, and then pair them up with other due process clause cases so that kids don't necessarily go with the obvious answer. I think that might help our kids if they see two due process clause cases on the test, and you know how they do. They get to Gideon and they automatically want to go to Sixth Amendment. And so it might be fun in our classes to compare apples and oranges and see if they can come to due process as the answer. So I thought one way I could approach this with kids would be to get them to sort out the difference between substantive and procedural due process. And these are hypotheticals I made up. So I hope they work. The first is a person who is protesting peacefully in favor of the legalization of marijuana. I'm from Colorado, so I had to use that example. In front of the United States Capitol building, the protester is arrested under a law that prohibits protests on state property. Well, that's wrong. It's not the US Capitol building. It's the Colorado Capitol building. Given access to an attorney and released on $25 bail. I thought this would be substantive due process because the protester was treated fairly. They were given access to an attorney, they were released on bail, but the law under which they were charged was unfair because we don't pass laws jailing people for protest. And then the second example, a person's found trespassing on private property and arrested. So, you know, clearly they've committed a crime. The trespasser is booked and released. Everything's good so far. Her trial is postponed for 3 years due to understaffing in the prosecutor's office. I felt like this was a violation of procedural due process because she was denied a speedy trial. So the law under which she was arrested was fair, but her treatment was not fair. And then I think what you could do is have your kids develop their own scenarios, create a Google Doc or whatever presentation software you use, and have them share their hypotheticals.
So someone's asking for clarification on what students would need to know about a case for a multiple choice question versus a quote required case for the SCOTUS FRQ.
Oh, that's a really good question. I'm so glad you asked that. That's a really good question. So what they need to know, there's 3 answers to it, but they're consistent. What they need to know for a multiple choice question is exactly what's in the CED. So they don't need to know anything outside of the CED. So the slide we had, let me go back here. The slide we had about Roe versus Wade, they need to know that the court held that substantive due process expanded the right of privacy to an abortion. It's right there. That's what they need to know. Now, there's an exception to that, and that is if they give the kid more context. So there might be a multiple choice question that describes a court case and then says something like, the case described is most similar to which case. But they don't really need to know anything to do that question because there would be enough context provided. So for a direct multiple choice question that asks specifically about a court case like Roe versus Wade, it comes directly out of the CED. This is exactly what they need to know. And I like that. I like that transparency. Otherwise, they'll give them some context. For the required cases, the 14 required cases, they need to know the facts of the case because remember, Part B of that question asks about facts and rulings of the required case and comparison with the non-required case. So they need to know the facts, they need to know the ruling, they need to know the constitutional clause or amendment. So for required cases, constitutional clause or amendment, facts of the case, and the ruling. And by the ruling, I really mean the reasoning, not just who won or lost, but why.
Are there some rights that can connect to both procedural and substantive due process? For example, procedural state procedures that arrive at the death penalty versus a substantive violation, such as the age of the person to be executed or the method of execution.
Yes, there's like the CED treats this like there's a neat division between the two. And the more I got into this to prepare for this presentation, the more I realized that these rights overlap in some cases. They don't overlap in every case, but they do overlap in some cases. And the one you mentioned is a really good example.
We have some questions regarding the hypotheticals that you wrote up. Could a violation of a civil liberty be a substantive due process claim? Some justices do not believe in substantive due process, so restricting a civil liberty would fall under a strict level of scrutiny.
So could it be? Yes. It depends on the interpretation of the judge, right? Some judges believe that there are substantive due process claims, and others don't. They're more restrictive to what is specifically stated in the Constitution. So the question was, could it be? Yes. It depends on the interpretation of the judge. Some judges give more leeway to substantive due process than others.
Did New York Times versus Sullivan get questioned recently? It's not a required case, but it might affect conversations about the Pentagon Papers case.
I'm not seeing anything on my list right now, but that doesn't mean it wasn't questioned. There may be something that I missed. So I'm going to go with I don't know on that one.
All the stuff you have to keep up with is like a second and third full-time job.
It is. And I'm so worried that I'm going to miss something. So I'm going to go with I don't know. I'm not familiar with it, but that does not mean it doesn't exist. All right. Well, let me share the FRQ I wrote, which you will have access to. And again, this is just something I wrote. It's not College Board approved or anything like that. But it was something I thought you would be able to use in your class. I wrote an FRQ and then I included a rubric with it. So I used the language from the College Board telling kids that they're going to compare a case they studied with one that they've not studied. And the case that they've studied in this case is Gideon versus Wainwright. And the one that is not on the required court case list is Mapp versus Ohio. And I gave them the facts of Mapp versus Ohio. And then I gave them the ruling in Mapp versus Ohio. And for those of you who are new, this is the pattern in all SCOTUS FRQs. They'll get a non-required case, they'll get enough context that they will be able to apply a required case to it. And so A is always identify a constitutional clause or provision or amendment. You may have to teach kids what a clause is. First time I gave this in my class this year, a kid raised their hand and asked what a clause was. And I always have to smile at the things that I think they know, that they don't know. I had a kid ask me today what constrained means. So, you may need to cover that with kids. And then explain how the facts in Gideon, and somebody asked, what do we need to know about what kids need to know from the required cases? They need to know the facts in Gideon. You will have a lot of kids who want to jump right in and talk about the ruling without talking about the facts, and they're going to lose points if they do that. Led to a similar holding as the court's decision in Mapp versus Ohio. And this is very standard language. For those of you who are new, this will either say a similar holding or a different holding, depending on the outcomes of the cases. And then Part C always takes the kids to a different piece of content. And in this case, I took them to federalism, how the holding in Mapp versus Ohio affected the balance of power between the states and the national government. So, some piece of content that's outside of this chapter that they've learned previously. You could always talk about, what Congress could do to change the impact of the court case, or what a citizen could do if they're unhappy, or something like that. And then I gave you guys a rubric. The answer to A is due process clause of the 14th Amendment. That this is my attempt to have them practice that. I would not give them credit if they said 14th Amendment. If we ask for a clause, they need to say it specifically. I also would not give them credit if they said something like really vague, like, the clause that requires the government to treat people fairly. I mean, it's not too much to have them name the clause. And then for Part B, by the way, is worth 2 points. They get 1 point for describing relevant information about the required court case. And I had kids do this today. They did a nice comparison of some cases and didn't really prove to me that they had read the required court case. So some piece of information, if you will, that proves that they've read and remembered the required court case. And then 2 points for explaining how the rulings are similar. So, and I gave you some examples here. In Gideon, the court ruled that defendants charged with felonies have the right to an attorney under the Sixth Amendment if they can't afford one. In Mapp versus Ohio, the court ruled that evidence obtained illegally cannot be used at trial. Both cases applied the due process clause of the 14th Amendment to the states to protect civil liberties guaranteed in the Bill of Rights. So sometimes I call this a fact sandwich in my classes. Facts of one case, that's the bread. Facts of the next case is the, delicious, I'm getting hungry. So like the delicious pastrami in the middle, and then a comparison statement at the end, that next piece of bread. And then explain how the holding in Mapp affected the balance of power between states and the national government. It gave federal courts more power over state actions, gave federal, and notice this is an explain. So kids can't just say it gave federal courts more power over state actions. They need a because statement. A little trick, when kids see the word explain on the AP exam, if they put because in the answer, it usually helps them link the content and make an explanation. And, you can see various rationales. I tried to write a question that had more than one rationale. So there were different ways that kids could get the points. So you're welcome to use this in your classes or modify it as you like. I just thought it would be a really good way of bringing that due process that's now appeared in the CED into your classroom so that kids could practice with it a little bit.
We do have one last question that I would love to ask Karen, if that's okay.
Oh, absolutely.
It's a really good wrap-up question. Is there anything else that should be on teachers' radars from the latest CED? This person said that they already read the CED, but is there anything specific that you would call out?
There really isn't. There have been, and Tiffany, you and I put out a little overview of the changes in the CED, I would just point out a couple of things, and I don't think these are going to change your teaching at all. One of the things the College Board did, and I think this is really good, is there are a number of terms in the CED that were not defined in the first version that are now more explicitly defined. And I really think that's good. Transparency is good. Whatever textbook you're using, it's probably already got a good definition of those terms. None of the definitions is weird or is, it takes us in a new direction. But look for more definitions that are throughout the CED. So I thought that was really helpful. And then I noticed one little tiny change in the argument question. In the version that they put out this summer, instead of referring to refutation, concession, and rebuttal, they just referred to refutation and rebuttal, which makes sense to me because kids were not conceding anyway. So for those of you who are teaching concession, I think you can kick that to the curb. It was really hard to do. It's like, why would you do a rebuttal question if the other side is right? So I think you can just focus on, making an argument that the other side would make. And I think you can avoid that concession language that was in there before. That made a lot of sense to me. So those were the big changes that I saw. This particular topic that we discussed tonight is the only one that I thought had the potential to change the way we teach the class.
Again, we're going to be sending out the recording, the PowerPoint, and this FRQ question at the end. But also, along with those resources, we'll be sending out that 2023 CED changes guide that Karen just mentioned. So it's going to list those specific questions and how it affects your teaching, if at all.
And I just wanted to thank everybody for coming tonight, because I know, especially for those of you who are on the East Coast, it's getting late and you've had a long day. You had to get up early to teach, and we're all starting to get a little bit nuts because this is the time when the curriculum really picks up. And so thank you so much for being here tonight. I know you gave up free time and time with your family to be here, and I really appreciate it.
Yes, thank you so much for everyone for joining. If we didn't answer your question, we'll reach out to you via email. And thank you so much, Karen, for presenting tonight. This was absolutely lovely. And thank you again to everyone who joined tonight. Okay. Have a nice night, everyone.
Bye, everybody.